cuddly baby canon. But indeed, it is not. We're going to talk about some of the problems with this new canon of interpretation. So let me start by telling you the canon. So the Supreme Court fairly recently, since the 2020s, that's how recent we're talking about, has stated in a couple of cases that if it is interpreting any causal language in any federal statute, that it is going to assume that Congress legislated against a default principle. And that default principle is that the plaintiff has to establish but for cause. And the court has said that it will use this presumption in both criminal and civil cases. And so the first thing I want to point out about this is that this is not the application of tort law to one particular statute. Instead, it's a different kind of invocation of power. And what the court is now doing is creating a canon of statutory interpretation that brings in one particular version of causation doctrine across all federal statutes. And so if you just sit and think about the magnitude of that choice, it is pretty high. And we'll talk about how the court constructed this canon and some of the implications of it. So the central ideas of the paper, for those of you who haven't had a chance to read it, the first one is that this is the first article to recognize the new canon and to give it a name. Now, the court has used the canon several different times, but this is the first time in the academic literature that someone has noted the canon. The court very strangely claims that the canon is ancient. In several cases, it also says the canon has a long pedigree. However, I think one of the benefits of the paper is it shows that the court created this canon actually fairly recently. And I think the canon really starts to form in 2013 and really gets steam in the early 2020s. The canon, even though it purports to adopt tort law, is actually inconsistent with tort law. And we'll talk some about the inconsistencies. And really, the canon is a huge challenge to current ideas about statutory interpretation and what the Supreme Court is doing in that realm. And I'll end the talk by discussing those challenges. So today, I'd like to give you a roadmap. I'll start by talking about just tort law generally. Then I would like to show you how the canon was constructed. So look at the history of the canon and how the court created it. And then I'll close with issues of statutory interpretation. And I'm really looking forward to the question and answer session at the end. So I think, as everyone on this call knows, that factual cause, at least in the US, and I'm interested to see if the Canadian system is similar, has two main components. And those two main components are factual cause, which is actually the real causation doctrine. And then we also have a doctrine called legal cause, which we also name proximate cause. And this isn't so much a causation doctrine, it's really about how far from a public policy perspective the law chooses to look at the consequences of particular conduct. And so the first thing I want to emphasize is that the canon that I'm talking about is a factual cause canon, and so we really won't be talking about legal cause or proximate cause today. Although, really interestingly, the Supreme Court has also started to use proximate cause as a doctrine to also limit discrimination law. So even though none of the employment discrimination statutes contain an explicit proximate cause limit, the court has started to infer a proximate cause limit. And so we'll just see if in the future that also becomes a doctrine like the factual cause doctrine. So I want to just do a brief overview of tort law. And so Anthony was kind enough to mention my amicus work at the Supreme Court. So I will just confess that I made this argument to the court and the court explicitly rejected it. So this was an argument that the court about the nature of tort law that the court has rejected. So if we actually look at tort law, factual cause is not one concept or one standard. It's actually a bundle of concepts. And this is a well-known feature of tort law in the United States. And I want to show you sort of how the bundle works. So often, in fact, quite frequently, the common law actually does require the plaintiff to establish but-for cause. So I don't want to make it seem as if but-for cause isn't a legitimate standard. It is. I don't want to make it seem as if requiring the plaintiff sometimes to carry that standard is not a legitimate use of causation doctrine. However, we know when we break down the but-for cause standard that we have two kind of ideas within it. The first is who has to establish causation? Does the plaintiff have the full obligation? And then second, what is the substantive standard? Is it but-for or something else? And one of the features of the new canon that the Supreme Court has created is that it smushes these two things together. So the plaintiff is always the person who has to establish causation, and they always have to establish it via but-for cause. And we're going to see in a minute that the Supreme Court, at least when it first started struggling with causation in the discrimination context, saw these two concepts as separate. In other words, when we're thinking about causation, there are two separate ideas. The first is who has to establish causation, and sometimes that will be the plaintiff and sometimes that will be the defendant. And then there's a second separate question about what the substantive standard is. And so one of the things that I'm really worried about with the causation canon is that it assumes that these two things are connected. And so it always forces the plaintiff to carry the full causal burden. And then it also requires that substantive standard to be but-for cause. So remember that I said that when we're thinking about causation, factual cause, it's actually a bundle. And this is because there are known problems with but-for cause. And in the sort of educational context, the law school context, we teach this bundle concept and the exceptions to but-for cause through two sets of cases or hypos. And the first case is Summers versus Tice, which I'm going to explain in a second. And the second idea is one of multiple sufficient causes. So the way that we teach factual cause in law school is the first standard we teach is the but-for cause standard. And then very quickly thereafter, after the students think they have it, then we say, okay, wait a minute, let's show you a couple of examples and we'll figure out whether but-for cause works. And then at the end, they figure out, oh, there's some circumstances where it doesn't. So you may be familiar with Summers versus Tice. I don't know if it's part of your curriculum. In the case, we have three friends who are out hunting. Two of the hunters negligently discharge their guns. They're actually shooting birds, and so it's shot that shoots out of their guns. Their friend is shot in the face, but very strangely, or at least the facts maybe are constructed very strangely. It's only shot from one person's gun who ends up hitting the friend. And so the friend cannot prove who shot him. And so we ask the students then, well, what would happen if we applied but-for cause and if we made the plaintiff establish but-for cause? And the students very quickly figure out that if the plaintiff was required to establish but-for cause, that the plaintiff would lose that case. This doesn't seem like the right outcome, given that we have two people who are breaching a duty and who are using their guns in ways that they shouldn't. And so the case ends up allowing a shift in who establishes the causal burden. So in other words, as long as the friend is able to show that the other two hunters both negligently discharged their weapons, and as long as the friend is able to show that we have the full universe of people who acted negligently, then tort law is going to allow a shift. So the plaintiff no longer has to prove but-for cause. Instead, the defendants have to absolve themselves of liability. In other words, the plaintiff has taken the evidence as far as the plaintiff can, and we recognize that it would be unfair to require the plaintiff to carry the full causal burden. So Summers versus Tice is just one example of where tort law sort of disaggregates the who has to prove question from the substantive standard in a way to promote fairness. Now, another issue that we have in tort law, or that we use in tort law to show this problem with but-for cause, is the two fires hypothetical. So I'm just going to look at the faces of the people I can see on the screen. Is this something that you've heard of before, the two fires hypo? So, okay, you use this as well. So I think in my classes, I make it even more unrealistic. So here's how I set the hypo. So imagine we have this very cute house that's sitting in the middle of a forest. Very strangely, on opposite sides of the forest, we have two negligent fire starters. Also, very strangely, they start fires at roughly the same time, and the fires are roughly the same size. And also, very strangely, they reach the house at exactly the same moment, one from one side, one from the other, and they burn the house down. And so what we do with the students is sort of take them through what would happen if we made the plaintiff establish but-for cause with fire starter A. And of course, the answer would be non-liability. And the reason is because we still have the second fire. And then we say, okay, well, why don't we just take fire starter B? How does that case end up? And again, if we walk through the plaintiff being required to establish but-for cause, we end up with a scenario where fire starter B also is not liable. So this is the hypothetical of multiple sufficient causes where we kind of have an over-caused outcome. And the students very then quickly learn that in multiple sufficient cause cases, that but-for cause doesn't quite work. And so in order to reach a fair outcome, we need to modify something about but-for cause. And what we typically end up doing in this scenario is we change the substantive standard to something a little bit lower than but-for cause, and we just make the plaintiff establish a motivating or a substantial factor standard depending on the particular state. So what we do in tort law is not just to say that we have a default rule, but we actually have lots of different rules, and we look at the facts of the particular case, and then we decide which standard from that bundle is appropriate to apply in a particular set of circumstances. And so it's this bundle approach that actually represents a correct articulation of tort law, not that there is just one default standard that is but-for cause. And so sometimes we do make the plaintiff, again, I don't want to give the impression that we never make the plaintiff establish but-for cause. It's just that in some factual scenarios, that is the right substantive standard to apply. But when it's not, the courts then choose from these other options that are in the bundle. And just because the other options are not commonly used does not mean that they're also not part of tort law. So one of the things I point out in the paper is that this kind of bundled approach to tort law is not some hidden feature. So it's not as if the Supreme Court justices aren't tort scholars, which they're not, right? So federal law is not typically tort law, and they're not generally experts on state law, where tort law is centered in US law. So it's not as if this is some obscure feature of tort law that they're just missing. Indeed, this idea is covered in the first year curriculum. And also, this is very, very strange. On multiple occasions, the Supreme Court has recognized that the bundle exists. So there are several cases in which the Supreme Court explicitly says that factual cause is not just one standard, but rather a concept that describes multiple standards. And the court has, again, in multiple cases, referred to these competing standards. So the court does know about the competing standards. It's within their easily accessible jurisprudence. All right, so that's the background on tort law, and I give you that just so you can see what a strange sort of journey that we're going to go on with the common law canon. And so now I'd like to turn to talk about the history of the canon and how the court created it. So I always love to see what comes up on the default slides in PowerPoint. And so very strangely, we just get Stonehenge. So when I typed in that I wanted a history slide, we got Stonehenge. My other choice was the pyramids, but I just chose Stonehenge as my option, but this was the default slide. So what I argue in the article is that prior to 2013, no canon existed. So there was no causation canon. Instead, what the court tended to do, both in discrimination cases and in other areas of the law, is to treat factual cause as a statutory specific issue. So what it did was it looked at, if we were in a textualist era, it looked at the words in the specific statute, and then trying to use those words within the context of the broader statute to figure out which causal standard to apply. Now, in the pre-textualist era, the courts actually did something very different, which is the courts tended to look at the underlying purpose of the statute and think about how the statute would actually work in the real world, and then it would craft the causation standard based on how the statute would interact in the real world and what the underlying goals of the statute are. And pretty interestingly, in this pre-2013 era, the Supreme Court sometimes created new causal frameworks that were not existing in tort law. In other words, they might look to tort law, but then they might also create a statutory specific factual cause doctrine that again was responding to the underlying goals of the statute as they existed in the real world. In these pre-2013 cases, the court often would recognize that tort law causation is a bundle, or at least there would be some discussion among the justices about competing visions or versions of factual causation. So I'm going to talk in a second about the Price Waterhouse case. That is a case that has a plurality opinion, two concurring opinions, and a dissenting opinion. And a lot of the discussion is about the options that the court has for factual causation, rather than just seeing causation as one particular issue that the plaintiff has to prove but for cause. And another feature of the pre-2013 jurisprudence is that the court also tended to see the substantive standard and the party required to prove it as separate questions. So again, one of the major features of the causation canon is that it inextricably ties these two ideas together, and that we're always forcing the plaintiff to carry the full causal burden, and we're also assuming that the substantive standard is but for. Prior to 2013, the court tended to see these two issues as separate, and as we'll see in Price Waterhouse, would sometimes then place the substantive burden on the defendant rather than fully on the plaintiff. So I want to talk about a very good example of this pre-2013 jurisprudence, which is Price Waterhouse versus Hopkins. This is one of the key cases taught in the law school curriculum. It's one of the key Supreme Court cases in discrimination law. And you may be familiar with this case. So we had a woman who had applied to be a partner at an accounting firm. She had gone up twice, actually. This was her second time. And it was unclear why she didn't make partner. Some of the partners in the comments in her promotion process had said that she wasn't good with clients. Others had said things that sounded like they might be based on merit, but also might be intertwined with her sex. So for example, they said that she was often rude to the administrative staff, but it wasn't clear whether men were being held to that same standard of being nice to the administrative staff. And then other partners used language that sounded like sex stereotyping. And so, for example, one of the partners who actually supported her candidacy told her that she needed to talk more femininely, walk more femininely, and wear makeup and jewelry. And if she did that, and the words are very strange, she would be a more attractive lady partner candidate, are the words that are in the case. And so the court was trying to figure out in this case whether she could prevail if the facts established that there were legitimate, not based on her sex reasons for her failure to make partner, but also discriminatory reasons. And the reason that the court needed to take on this issue is that the prior cases, or many of them, had often dealt with a single causation issue. So the only issue in the case was whether we believed the plaintiff's version of the events or whether we believed the defendant's. And if you believe the plaintiff's version, then the only reason that they were discriminated against was because of a protected trait. And so largely, but not exclusively, the cases that the court had dealt with prior to Price Waterhouse had just focused on this who do you believe versus whether we could have multiple causal options, some discriminatory and some not. So in Price Waterhouse, if you were thinking that there was an ancient causation canon with a long pedigree, you think that the court might have mentioned it in the Price Waterhouse case, because this case is being decided at the beginning of the textualist era. And so if we were going to claim a textualist canon, we might have seen it in this case. Even the dissent, which tends to have the conservative justices, or some of them, does not mention a canon. So that makes me very suspicious that this canon existed. And instead, what we get in Price Waterhouse, again, in the plurality and in the two concurring opinions, is more a focus on the statute itself. So looking at Title VII, the federal statute that prohibits sex discrimination, looking at its text and its purposes, and then looking at how the text and purposes will react in the real world. So in other words, the plurality is looking at who has the information about why Ann Hopkins was not hired. Is that information that she has, or is that information that the partners have? What kind of difficulty would she have in proving discrimination? In other words, how far can she take the evidence that she has? And then also, what do we do when we have multi-member decision-making bodies? So for example, what if Fred thinks that her work is terrible, but Tony wants to discriminate based on her sex? How do we then aggregate those disparate voices from the promotion process and figure out what caused the outcome? And so the court then takes in all of these inputs and creates a causal standard that doesn't really mimic tort law at all. And so the opinion explicitly recognizes that tort law does not always require a plaintiff to prove causation. And also, these are words from the actual decision, which is kind of ironic given what the court's done recently. But to understand the words because of, to require but for cause, is to misunderstand them. And that's a direct quote from the Price Waterhouse decision. So what the court ends up doing is adopting a motivating factor standard and then separating the causal standard and who has to prove it. So let me just show you how this works. So under Price Waterhouse, what happens is the plaintiff has to show that sex was a motivating factor in the outcome. And then the court says that after the plaintiff has done that, that's as far as the plaintiff can take her evidence, and the plaintiff will win if the evidence stops at that point. However, the court gave the defendant an affirmative defense to both liability and damages. If it can prove that it still would have made the same decision absent any of the sex discriminatory comments or motive, then it wins the lawsuit. So in other words, if there's kind of this brew of legitimate and non-discriminatory reasons, the plaintiff isn't required to untangle that fully for the court, because the plaintiff simply doesn't have the evidence. She doesn't know what really happened in the room when they were making the choice. And so we only require her to carry this partial burden. And then we sort of end up at but for cause at the end, but only by then switching part of the burden to the defendant. So notice we get two things that are interesting given the court's recent moves. We have the motivating factor standard, which is not the but-for cause standard. And we also have a disaggregation of who has to prove the causal standard, with the plaintiff proving some of it, and then the defendant, to escape liability, having to disprove that sex played an outcome in the role, or that it would have made the same decision anyway. Now, pretty interestingly, Congress responds to Price Waterhouse by explicitly putting in parts of Price Waterhouse into Title VII. So in 1991, Congress amends Title VII. And what it does is it liked Price Waterhouse. So it says, yes, that motivating factor standard is right. However, Congress believed that the court was a little too defendant friendly in the affirmative defense. And so there's still an affirmative defense in Title VII, but it's only a partial affirmative defense as to damages. So in other words, if the plaintiff establishes motivating factor now under the statute, the defendant can still get some of its damages reduced if it proves it would have made the same decision anyway, but the plaintiff still technically wins the case. So again, the 1991 amendments affirm Price Waterhouse, but change the affirmative defense slightly to make it more plaintiff friendly and less friendly to defendants. So then we jump ahead to 2009, and the court is asked to take on basically the same issue in the age discrimination context. And I don't think that anyone would have read the Gross case as creating a canon. And I actually don't think that it even creates a canon. But now that we've seen the canon emerge, you can see the court kind of slouching towards a canon or crawling towards a canon. So if we look at Gross, where the court is asked, what's the causal standard under the Age Discrimination in Employment Act, we get a very ADEA specific reasoning. There's almost no reliance on tort law. In fact, the court says that we're just making a decision based on what we see in the Age Discrimination Act, and mostly Congress's failure to amend the ADEA when it amended Title VII to respond to Price Waterhouse. So let me talk about that a little bit more. So in 1991, when Congress specifically included this motivating factor standard in Title VII, for some reason which is not known, it also did not amend the Age Act. And so it left the Age Act as it originally existed and did not include this new standard in the ADEA. Now, what was hard, I think, about the Gross case is that the Age Act basically adopts the language of Title VII almost exactly, with very few exceptions. The causal language is exactly the same. So the language of Title VII, because of, and then a protected trait, is the exact same language in the ADEA, except the protected trait is age instead of race, sex, or other characteristics. And so you might think that Price Waterhouse then would have been the precedent to which the court needed to refer in Gross. Instead, what the court does is it views the non-amendment of the ADA in 1991 as a clue that Congress meant for the Age Act to have a but-for cause standard and for Title VII to have a separate causal standard. Again, so the primary sort of idea in Gross is that it's the non-amendment in 1991 that causes a different outcome. And so in 2009, we get Gross, where the court interprets because of in the Age Act to mean that the plaintiff has to establish but for cause. Now notice what we have now going on. In Title VII, we have the language because of, which doesn't mean but for cause. And now in the Age Act, the words because of do mean but for cause. Now, one of the things that's interesting about Gross is while it does assume that the plaintiff is the default bearer of the obligation, it still sees the substantive standard as a separate question. So it separately takes on the who has the obligation question from what the substantive standard is. Now, this is also extraordinarily important because Gross is written by Justice Thomas. The court does not claim a canon exists in 2009. So again, if we had this sort of ancient canon with a long pedigree, by 2009, you think the court would have claimed it, but we get no claiming of the canon. So in the paper, I also go over a lot of other pre-2013 cases that involve causation. And in none of those cases does the Supreme Court claim that a but-for canon exists. So the case that really starts the canon, or I say maybe, because we only know that it starts the canon when we look in hindsight now that the canon has been articulated in a couple of cases, is the 2013 case of Nassar. And this is a case that I filed an amicus brief in and was on the losing side. So Nassar worked for a hospital He claimed that he was being discriminated against and retaliated against based on his race and his national origin. Causation, at least for the retaliation provision, was the issue that wound its way up to the Supreme Court. And the ultimate ruling for Title VII retaliation claims is that the plaintiff has to establish but for cause. And if you look at the words on the screen, we now see what's sounding more like a canon. So in the usual course, the standard requires the plaintiff to show but for cause. And that sentence is actually correct, right? So in most instances, the standard does require the plaintiff to establish but for cause. It's just that that sentence is incomplete and that it doesn't allow for other instances where we've shifted the causal burden to another party or we've lowered it. And then we get what I think is actually now the canon. The rule is that there's a background against which Congress legislates, and the background rule is the plaintiff must establish but for cause. And then notice this is where we get the statutory interpretation canon. The court is now going to presume that unless Congress tells it something different, that this is the default rule. Now, what's really interesting about this is that, of course, most statutes in the United States were created by Congress prior to 2013. We get the first invocation of this canon in 2013, yet somehow Congress was supposed to understand that the court is now going to make this assumption for statutes that were enacted prior to its invocation. So I think some of the key aspects of Nassar, and I'd really recommend that you read the opinion. It's really a marked sort of break or departure from earlier cases. Nassar claims that this default standard has a long pedigree, but really, Nassar is the first one to fully invoke it. And one of the things that's odd about Nassar, and while I'm reluctant to say that it is technically part of the canon, is that it's actually not clear if the discussion about tort law and the canon is dicta and whether it was actually required for the eventual outcome that the court reached. And then very interestingly, the court in Nassar still recognizes other substantive options under tort law. So while it wants to have this default rule, it still recognizes that there are other possibilities for factual cause. Now, then very quickly, we get the canon, I think, solidifying. There's a criminal case called Burrage, which is actually also an interesting case to read. While it recognizes that there might be other causal standards, it also applies the statutory canon that we assume the plaintiff has to establish but for cause. And then we really get the canon solidifying in the Comcast case. Comcast was also a discrimination case. It was brought under Section 1981, which is a separate federal statute. Section 1981 only covers race discrimination cases. And Section 1981 was actually created right after the Civil War during the Reconstruction era. And one of the reasons why I think Comcast is extraordinarily interesting, and I also wrote a brief in that case, which was also rejected just for the full record, is that Section 1981 actually doesn't use any tort language, and it doesn't contain any causal language at all. So when the court is applying the canon to Comcast or Section 1981, it's implying that the statute has causal language, and then from that implied causal language, then assuming that the plaintiff has to establish but for cause. Now, one of the things that we argued in the Comcast amicus brief, which again was not the the argument that won the day, was that tort law does have this bundle of options, and that while there can be a default rule, the default rule has to allow for the options where tort law or the default rule does not get the correct outcome. We also argued that it's really, really strange to apply modern tort law to a Reconstruction era statute where torts wasn't even really recognized as a fully functioning field until long after Section 1981 was created. Again, neither of those arguments won the day. So again, in Comcast, we get this rearticulation of this supposedly ancient and simple rule that but-for cause supplies the default background rule against which Congress is normally presumed to have legislated when it's creating new causes of action. Now, it's possible for Congress to signal that it is opting out of this default rule. And there was a case right after Comcast was decided. It was a BAB case. It was decided under the federal sector discrimination provision, where the court looked at the words of that statute. And so those words said free from discrimination. And the court held that under those circumstances, that Congress had spoken and that the default rule sort of no longer applied. So in Comcast, we get this articulation that it's textbook tort law that a plaintiff seeking redress must typically prove but for. And for the ancient rule with a long pedigree, here are the citations, just in case you're curious. A citation to Nassar, which is a 2013 case, and then Nassar's citation to a 1984 treatise. So I just find it very unsatisfying that if we have this ancient doctrine with a long pedigree, that we're going to use citations from 1984 and 2013, especially when the court's struggling with a statute that was created in the late 1800s. That just the order seems odd and that doesn't seem satisfying. And then, of course, we get to the Bostick case where the court decided that gender identity and sexual orientation are prohibited traits under Title VII for discrimination. And the court again claimed that but-for cause was the default rule. What's really strange about Bostick, though, was that the court wasn't actually claiming but-for as the default for Title VII discrimination claims, because as I stated earlier, that's not the correct standard. Instead, it was using this but-for cause argument as a rhetorical argument to show why gender identity and sexual orientation should be prohibited under the statute or the discrimination. So the key points from this section are that the canon did not exist before 2013, and any claims that the canon is ancient are easily disprovable by just simply reading recent Supreme Court opinions. So then I'm going to largely, in my last 10 minutes or so, look at some of the issues that this raises with statutory interpretation and show you just some of the tensions here. So those of you who are familiar with the current Supreme Court are probably familiar with this move to textualism. Some forms of textualism are stronger than others. So in some forms, it's just the general idea that the words that Congress use matter. I don't think that that's fairly controversial. Stronger forms of textualism, though, say that it's only the words that matter or only the words in context that matter. But if words matter, then the canon is a little bit problematic because it applies the default to almost any causal word that Congress uses. So whether those words are based on or because of or results from, those are all words that the court has seen as causal words. And even though they're different words, the Supreme Court is going to apply the same default. So that seems strange to me that Congress can use lots of different words, but oddly mean always the same thing. And then second, when the court has applied the canon, it has tended to look at particular words like based on, because of, results from, instead of looking about how those words play in the broader context of the statute. And so this, I think, actually violates a central tenet of textualism. So textualism isn't just about looking at particular words, but it's about looking at those words in the context of the statute. And so this canon has tended not to do that. So another sort of interesting issue that's posed by the canon, or actually what I would argue should be the canon. So if we had a canon, it would be a bundle of concepts canon. But if we were to actually adopt tort law in this context, what we would end up with is a statute that uses one word, but that one word or two words has multiple meanings. And textualism actually hasn't dealt with this possibility from tort law. So if we think about tort law, what tort law tends to do is to identify elements of a claim, and those elements are usually quite short. But then it allows within each element for there to be a lot of variability. So if we think about causation or factual cause, we have all of these bundles. But if we're thinking about a negligence claim in the US, we just say breach of duty causing damages. And we just use causation as the word. And we know that causation can then legally mean many things. Textualism, though, has a problem with this because it tends to claim that words can only have one meaning within a statute. But if we're now going to adopt tort law into statutes, we're going to have to think about whether that means that words within statutes can have more than one meaning, just like those words would have more than one meaning in the underlying tort law. So then the paper also raises some other questions, which I'm just going to raise briefly, and then we can talk about them in the Q&A. It's unclear actually where the common law generally fits within the overall taxonomy of statutory interpretation. What kind of canon is it? No one seems to know. There's no consensus. So I looked at the scholarly literature. Depending on who you read, the common law canons are called lots of different things. It's not clear when it's appropriate for the court to invoke common law through canons. Does the statute even have to use a common law word? What happens when the statute largely rebukes tort law? And I would say that Title VII is a huge rebuke of tort law because it overturns the at-will employment presumption that applies in most tort law in the United States. How settled does the common law have to be? In other words, if we have a new idea in the common law, does that somehow get brought into the statute? Or do we somehow arrive at a fixed version of the common law that we then import into the statute? And so over time, the tort law would continue to evolve, but the statutory law would remain static. It's unclear what's supposed to happen there. Does the court even have to use the common law, or can they just claim that they're using it? And then again, can we have these statutory meanings changing over time with the common law, or do we have a fixed idea? So I just sort of want to end by reframing the central idea of the paper. The court has chosen a version of causation that does not mimic the common law. It has claimed that it's following the common law, and now it's enshrined that choice as a canon of construction. So in some respects, I'm very skeptical of what the court did in this series of cases. It is a sort of careful study in the exercise of power. So, and the court, I think, has carefully hidden what it has done by, again, trying to make it seem as if we just have taken this ancient tort law principle and now very innocently translated it into a canon. But again, I just want you to notice what the court has done. It has taken a very narrow version of causation and now enshrined that as a canon of construction. And so with that, I'm actually going to unshare my screen so that we can see each other better, and I welcome your questions and comments.
Thank you so much, Professor Sperino. That was a very interesting and sort of comparative lens topic for us. So as mentioned at the beginning, I'll take a cue for the Q&A. So to get on the queue, just use the hand raise function on Zoom or send me a direct message in the chat, and I'll get the queue going. The first hand I see is from Joanna Langell.
Hi, Sandra. Lovely to meet you. Thank you so much. That was absolutely wonderful and so easy to follow this incredibly complex argument. So I learned a huge amount. Thank you. So I have a question which sort of sets aside the stat interp aspect of your argument. So I might, I'm not a stat interp person, I'm not an expert in the canons. Maybe we agree this is like a bad way to do canon work and it's not consistent with textualism and so on. But as a matter of tort law, I wonder if this is such a bad presumption, right? Because I would have thought that the instances you pointed us to, like the two fires examples, the two shooters examples, where we think we have to relax but for causation to achieve a just result, I would have thought that those were very difficult cases for tort law, and that's why we study them. Because we actually think the idea that tortfeasor actually has to have done something to a plaintiff or to a victim as being a very important part of deciding that one person has violated the rights of another. And so I wonder whether, to me, we could think of this as a sinister power grab, or maybe the Supreme Court recognizing an important aspect of the kind of internal morality of tort law, right? That this is sort of a default that we should have, and those other cases, maybe discrimination should work differently. I can think of reasons why, and maybe they're wrong in those instances, but is this really such a bad canon if we think about what tort law is doing?
All right, those are great. I'm going to actually answer a couple of other questions that you didn't ask, and then I will answer your question. So, it's unclear what's going on as far as whether they've considered it to be a good rule or not. One of the interesting things that happened in Comcast is that all of the progressive or liberal justices, their dissents went away. So it used to be that whenever we were having this fight about causation, there would be a split, and it would usually be the more liberal justices and then the conservative justices. And in the but-for cases, the liberal justices continued to dissent over time. They've stopped dissenting. So I think they've now decided that we're done fighting this fight. And so we fought it so many times, and we have to make a choice. And so we're making a choice. And I don't know if that's because they think that the default is the best presumption. My guess would be is that we can't keep having this fight over and over and over and over again. And so it just makes sense. And sorry, that's my telephone going off. So it has a really nice ring. It sounds like I'm getting a lovely prize, but that's my telephone. So they've stopped fighting that fight. And I think it's just because we have to make a choice about having a rule. And so now we have one. Now, what's really interesting is that the Bostock case may make this fight a little less important. And so here's the interesting thing that happened in the Bostock case. So in Bostock, the court relied on this idea of but-for cause to reach its outcome. But in doing so, it also recharacterized but-for cause. And so Justice Gorsuch's opinion says that but-for cause is sweeping. He recognizes that there can be multiple causes with but-for cause. And he says it's not a narrow standard and it's not onerous. So one of the things that's interesting about Bostock is that the court didn't accurately describe but-for cause, but in making it seem so non-problematic, it may have actually fixed some of the problems that the lower courts were having with applying causation, because now the plaintiff's bar is citing Bostock to the courts, and they're saying, oh, it's not narrow. Oh, it is sweeping. Oh, we can have multiple things happening. And even though Bostock doesn't describe it quite correctly, it may be that sort of oversimplification kind of wins the day, and these arguments about what the causation standard are may not matter anymore. Now, I actually think that there are lots of employment cases where we have multiple sufficient causes. And that's because we often have one instance of this is where we have multi-member decision-making bodies. And so let's assume that 3 people are making a decision, and one person says one thing and one person says another and one person says another, and they're all sort of going into the mix. And we actually don't know. It looks like they all came together to cause the outcome. And so that looks a lot like the 2 fires or maybe 3 fires hypothetical. And we also have sometimes over-caused outcomes. So, you were fighting and I'm also discriminating against you. And so I'm just not sure that but-for cause is the right standard. So, but I don't disagree with you that sometimes applying but-for cause and making the plaintiff prove it is not a good standard to use some of the time. It's just that it doesn't work for all factual scenarios. Thank you.
Sophia.
Thanks, Sandra. That was fascinating. I really learned a lot, and those are wonderful issues for us to be thinking about. So I had 2 questions, but I just wanted to say add at what we sometimes call a finger in response to Joanna's point. I guess I actually just came off teaching the Canadian versions of these complications to the but-for test today to my tort students. we have a case called Cook and Lewis, which is very much like the Summers and Tice. And then we have a series of cases in which there are multiple sufficient causes. And I guess I've always assumed that those show that there are problems with the but-for test, even in those cases where it appears to work. Because it seems to me it couldn't possibly be the case that the but-for test tells us, well, the but-for test says, look, causation is about being a necessary condition for something. It couldn't be the case that in the cases where the but-for test works, that's really what causation is. It's being a necessary condition. But in this 3 or 4% of cases where it doesn't work, being a cause is something else. That just seems bizarre. So it seems to me that what the cases where the but-for test doesn't work show us is that the but-for test is, even in the cases where it does work, maybe a good measure of whether something is a cause, but not actually a definition of what a cause is. And that just seems to me then to show that we need to think in all cases about whether it's a good measure or a bad measure. So I guess that brings me to my first question for you, Sandra, was just about one of the interesting problems that I'm wondering whether it lurks under the surface of your talk or maybe was implicit in what you were saying. When we try and import the but-for test from the tort law context to the discrimination law context, in a lot of torts cases, when we're thinking about causation, we're thinking about a causal chain that primarily involves physical events in the world. I drive my car too fast, it then hits someone, the person is injured, or I fire my rifle, and then the bullet goes into someone and they're injured. But once we're into the context, at least of discrimination law, where we're talking about intentional discrimination, we're dealing with these cases where although we talk about and we're looking for a cause, the cause works its way through people's motivations. So when we're talking about intentional discrimination, we're thinking about motivating factors. And there, it's just not obvious to me that the same test would work. So I'm wondering whether part of that is the problem that we're importing a causal test that seems to work well as a measure of causation in a lot of torts cases where we're dealing with one context, the context of physical events having an impact on each other. And we're then bringing it into a context where we're trying to talk about people's motivations in a complex way, and the test is problematic there. And relatedly, I guess this goes to the interesting point you mentioned about the burden of proof. We might, in certain contexts within tort law, assume that the two parties, the plaintiff and the defendant, have equal access to evidence about causation. Whereas once we move into the context of intentional discrimination, it seems obvious that in a lot of cases, it will be the alleged discriminator that has much more evidence about the decision-making processes and the motivations than the claimant does.
Yep, those are all wonderful comments. In fact, in Price Waterhouse, the plurality opinion does sort of raise this issue of we've developed tort causation largely with physical events that are happening. And so it necessarily, the causal standard should necessarily change if we're dealing with mental states. Now, one of the things that's pretty interesting about this move to causation is it actually, in some senses, may end up helping some plaintiffs, because the court just recognized in an opinion that was issued, I think it was last week or the week before, in a kind of corollary area. It was a retaliation case, but not an anti-discrimination case, that intent is not required and it's actually causation. So it's weird because, we all talk about intentional discrimination, and at least Title VII does not contain the words intent in its main provisions. And so it may be that this focus on causation, while problematic, also gets the court away from these really strong versions of intent, and instead focuses on just did in retaliation, the protected activity, or in discrimination, the protected trait, lead to the outcome. And so we no longer may be forced to kind of mediate the intent of the actors, although that is often the strongest evidence. So I think you're exactly right that shifting from sometimes what are internal mental states from physical events in the tort world does justify a difference. There's also a weird thing I think about the causation jurisprudence, and that to me, causation is a connecting term. Like, what are you connecting to what, right? And causation's in the middle. And so to me, if you change the things on either side, that also changes the nature of the inquiry. And so I don't know how we, breach of a duty causing damages is connecting, two sets of things, and we're connecting different things with discrimination law. And so I don't know why the central concept should be the same.
That's really interesting.
Yeah.
Thanks. Yeah.
Zoe?
Right. I think what you just said there sort of answers my question, but I'm just going to do it again anyway, because right. So that was really clarifying. I really enjoyed that. So I think it's like a two-finger moment. I'm going to follow up on Joe's and Sophia's comments. So I took my colleague Joe's as saying something along the following with but for causation in tort law, right? The idea there is that, as you say, it's the connecting term, and it's connecting between, say, the defendant's either intention or negligence, and then the damage that results. And the reason for this is that we don't, except for a few multiple tortfeasors, like cases with products liability issues, right? We normally wouldn't impose liability for just the negligent imposition of risk alone. That so it's actually very important to us that the defendant actually is a cause of the damage that the plaintiff suffers. Otherwise, liability is just imposed by virtue of them being negligent, and we don't do that in tort law. But I think what you just said there was really illuminating, right, in terms of that maybe the causation inquiry in discrimination law is different, because when you're talking about Price Waterhouse, I thought, here we have, if one of the reasons for which she was not hired was actually, as we would say, like a non-tortious reason, then it seems to be the case that there should be tort law would say there's no liability, right? Because your injury would have been caused, or your damage would have been suffered regardless of the defendant's negligence. And that strikes me as kind of the incorrect result in that case. If you have a non-tortious, if you have a discriminatory reason for the lack of promotion, and a non-discriminatory reason for the lack of promotion, is very disambiguate which one was a cause of it, right? So I think there's just going to be a different inquiry involved, and so I agree with this kind of thrust that maybe the tort law concept of causation is not appropriate for discrimination law. However, I would say in tort law, generally the but-for test does a significant role, and only in cases where, like, causal overdetermination, which are quite rare, or in cases where each defendant has this thing where they point their finger at another defendant and will avoid liability by virtue of having other potentially negligent defendants in a way that sort of messes with the burden of proof. In those situations, we might choose to use a different test, but but-for is still a default test. But again, I think you answered my question before I even started speaking. So, but thank you for your talk and for taking the time.
Well, let me add something, because I think your comment's really insightful. So in the BAB case, which I didn't get to talk about very much, it's the federal sector provision for Title VII, which applies to the federal government as an employer. And it uses the language that all employment actions shall be free from discrimination. And what the court interpreted that to be is a causal standard that's even less than motivating factor, although it's not fully clear what it is. And then the court said, in order to get certain kinds of damages, you still have to establish but-for causation to get damages. So liability has this lower standard, and then damages have a higher but-for cause standard. And so that's maybe getting a little bit at what you're getting at. But what I find unusual is the courts have also declared that the purpose of Title VII is to make employment discrimination or decisions free from discrimination. And so if that really is the standard, there is a possibility that we do want to punish employers who allow protected traits to play a role, even if it's not a but-for role in the outcome. Now, maybe we don't make that choice for a policy reason. We think there's going to be too much litigation or too much liability, but it is possible that, like in the federal sector provision, that what we actually mean is stop taking these traits into account. And that you may need a lower causal inquiry if that's the outcome that you want.
I'll go ahead and insert myself into the queue now, Sandra. So I think maybe my question is similar to what's been asked, but my thought is has to do with the kind of recommendation to keep in mind the idea that causation in torts is a sort of bundle concept, and it's not just limited to but-for causation. So there's this canon now of reading in the but-for conception of causation when sort of causal language is used in, say, an anti-discrimination statute. If the recommendation is to keep in mind that there are alternative standards, and to sort of recognize that that particular canon is indefensible, it still sort of leaves the door open for but-for causation to be imported in alongside other standards for like overdetermination cases or something like that. So I wonder then, so the argument can be, first, don't recognize this canon, but second, I think, is there anything else to say which choice amongst the bundle matters for a particular statute? Maybe that's driven by linguistic conceptions, textualist conceptions, but it seems like kind of when we're talking about so in Hopkins, there was a good reason for wanting to accept the burden shifting framework, for example, that it was somehow furthering the purposes of the legislation. Congress agreed and took it even further, that sort of thing. If we're not willing to accept the proposivist view, if the current structure of the court is not willing to accept it, then are we sort of left at the, without any basis to choose between the bundle?
No, that's a great question. I mean, the choice among the bundle has, I think, always been in part driven by policy. So it's always going to be a little bit ambiguous as, and based on who the choosers are. Now, there is a bill that has never passed, and it's been proposed multiple times, and it's actually, I can't remember what so we like acronyms in US discrimination law. You may have figured this out already. So this bill is called PAWADA. I think it's the Protecting Older Workers Against Discrimination Act, PAWADA. And what this act does, and it's also clever because it appears to just be an intervention into the Age Discrimination Act, but actually if you read the statutory language, what it would purport to do is to change the causal standard in all employment law federal statutes to be motivating factor instead of but-for cause. But that has never gotten any congressional traction. So, I think the next answer would probably be a congressional action, or we do see some states that have changed their causal standard for their own state discrimination law. So that could be another option. Can we talk about Canadian law?
I was actually going to bring that back in,
Yeah.
Sandra, so if I can. Part of what motivates me in asking the previous question, right, is that as I spoke about before kind of the formal session began, under section 15 of the charter, our anti-discrimination constitutional provision, there's been a recent use of the language of causation, which hasn't appeared before, in order to show a link between like a challenged law and some disproportionate disadvantage against some group. And it seems like the court has really not defined the concept of causation very well, but it does seem to it hasn't used the but-for language. It's used something else, and I think it's kind of the idea is it has to be some factor, but not a dominant factor or a central factor, that sort of thing. And it's sort of already proven to be an additional hurdle or burden. And I guess I wonder whether there's space to have a kind of more claimant-friendly standard in the way that the causation hasn't been dispensed with. It's not dispensed with in statutory human rights law in Canada either. It hasn't been dispensed with under American statutes either. So I think it's useful to think about what ways of choosing between causal standards make sense in the absence of specific language. That's in the absence of a sort of textual approach, because there's no language of causation at all in our constitutional anti-discrimination provision. So that led to my question about whether it's proposivism that's doing the work, and you can have a sort of valuable purposive conception of causation, maybe some kind of burden shifting framework, for instance, or an affirmative defense. And so I guess that's motivating. That's actually motivating my question about what do you do? How do you choose between the bundle if the language doesn't settle it?
Yeah, I mean, there's also another option, which some English compensation discrimination law adopts, which is if you have a disparity, then it's up to the employer to prove that it wasn't based on a protected trait. So I think there are some areas of discrimination law that you could presume a violation under some narrow set of circumstances, and then actually put all the burden on the defendant to disprove. I mean, that's just another policy choice.
Do you think that some of the rationales for, like from Hopkins, that sort of attenuate the causal standard for the plaintiff apply to challenges against laws, against legislation? One of the arguments, right, is that employers, or in that case, the partnership, is in the best position of the evidence that it was relying on its own intentions, right, and being able to sort of disprove that its intentions were tainted. And I guess I wonder whether that same rationale for shifting the burden applies to legislation when we're thinking about whether, I mean, so one question could be, did the legislatures, are they able to disprove that in their deliberations they didn't have one of the protected grounds in mind? But that seems like a kind of, I don't know if that's an inapposite comparison.
Yeah, I think we have the opposite presumption here in that we sort of presume legality of sort of like a congressional intent. So here we wouldn't be able to make that presumption. But are you saying that this causal thing is fairly new in the Canadian jurisprudence?
Yeah, I think it is. I think it's only really been explicitly introduced in the past couple of years. One case, I would say. I think it also has some roots in the same way that you're suggesting. The canon has roots in previous cases, but I think it's relatively new. I'll let Zoe jump in here.
Yeah, go ahead.
I might have just misheard something, but there's an idea that the presumption that the wrongdoer is not, the defendant is not a wrongdoer, that it could be a policy choice. Like there are cases in Canada, so you said Summers and Tice, and that's in the US, and in Canadian Cook and Lewis, which is complicated actually, because it's actually a trespass case, so it's a little complicated, but where the burden shifts. And there's like various reasons we can explain about why that happens to the defendant, but I think there's something really important about why the plaintiff has the burden, like of proving that the defendant is a wrongdoer, because the presumption is that the defendant is not a wrongdoer, right? And so only in some situations where like you make different arguments, you can say something like maybe the defendants together are sort of eroding the evidentiary rights or the civil like recourse rights of the plaintiff or something like that. You can make an argument for why the burden can shift. You can say, listen, we're fine with 51% or 49% error, so we'll be fine with 49% error the other way. That's how the arguments tend to go. But I think it's more than just a policy choice about, and I think, and Anthony, when you were talking about being plaintiff friendly, like a standard, like in tort law at least. So I don't like discrimination, I don't know anything about, as you all know, but but like it cannot be plaintiff friendly, right? Because then it's just not a standard, right? The standard is supposed to treat both parties equally. And so if something is plaintiff friendly, that would be a problem for me in terms of tort law's ability to treat the parties before it as equals. But maybe I might have just misheard. But anyway, that's my I have 3 fingers now, because I'm now like, I don't know, it's so if I choose the 1 finger, this is maybe 3, but those are my interjections, which might be wrong.
Yeah, in the compensation, in the British compensation cases, I think the fact is that the plaintiff like shows a set of circumstances which the law then deems to be sort of presumptively fishy, I guess is the best way to put it. And so it isn't that the plaintiff has no obligation, it's just their obligation is to like get their case into a certain set of cases. And then because we think it's so fishy, then we make the defendant sort of disprove its way out.
That happens in our like law too. So you had the case like Snell and Farrell, like this horrible case that involves eye surgery, and then the eye explodes. It is awful. But the question is like, the doctor's in there messing around. He's like, yeah, like it wasn't me, she had this natural thing, she had a stroke. And they're like, yeah, that seems a little bit like the eye in which you operated on somewhat negligently is the eye that she is now blind in. We're going to say, like, we're making like a common sense inference, they call it, that you were responsible for that. Like that. So, and now you, defendant, you can disprove it. Why? Because you were in the eye mucking about. So you're the one who knows. Is it like, because you might notice in Summers and Tice, isn't it the case that the plaintiff, like with the shot that went to the plaintiff's eye, isn't the case that like one of the defendants had an 8-gauge shot and one of them had a 6-gauge shot, and the plaintiff had the shot, he'd like had it in like a chain around his neck, and then he lost it, and so they could have actually proven which one was the one who did it. It's either the American case or the Canadian case. I never.
Oh, I've never heard that.
Yeah,
I'm
so
gonna
there's
go
two
look that
different
up.
shots, right? So because the way the shotgun pattern goes, they overlap, but only one little pellet went in the plaintiff's eye, and the truth was the plaintiff like had it and then he lost it, and so that was why they for both of them were held liable. But he could have, because the idea is like, oh, you've got the better evidence, defendants, you as between you, but turns out the plaintiff actually would have been able to choose. So
Yeah, to me, somewhat the facts of Summers are a little bit constructed, because if you actually read the case, it seems like he got shot in the jaw and in the eye. And so then to me, there's 2 pieces of shot. And so then I don't know how we can say they just, but maybe he did have them at some point. I don't know.
Any further questions? I think this has been a great discussion so far. Maybe we can sort of leave it at that and a little bit early then. Everybody join me in thanking Sandra for a really wonderful discussion. A lot of us for issues for us to continue thinking about, and especially right bumping up against your teaching time, Sandra. Thank you for joining us there, and looking forward to continuing our speaker series. See you next month.
Yeah, I hope this results in collaborations. Thank you for joining
Yeah.
me today. I appreciate it.
Thanks so much, Sandra. Thanks, Anthony, for organizing.
yeah,
Yes, thank you, Anthony.
Thank you.
Bye, everyone.
Bye-bye. Thank you. Well, that was great. And we got a good turnout. So excellent.